Now today we will focus on nuisance. Normally we describe an undesirable person as a nuisancical chap, right? But actually, nuisance does not relate to persons. That is the first thing that you have to understand about the thought of nuisance. Nuisance always arises because of the use of my land. I use my land, okay? When I do that, use of my land results in unlawful interference with the person's use or enjoyment of some land, some right over the land. So, the perpetuator is normally a landowner or a tenant or an occupier, whatever category he may be. The sufferer is also a landowner, tenant, and is never a perpetuator. We have two types of nuisances. One is a public nuisance, second is a private nuisance. Okay, welcome, Amar. Let's go back to the slide. Public nuisance, private nuisance. Now, first let's look at private nuisance. In order to constitute private nuisance, three essentials have to be proved. Number one, this point number one has two components in it. First is interference. Second is unreasonable interference. Okay. Between 6 and 7:30, I take classes and therefore I shout. My neighbors cannot be too upset about it actually. But if I do it by 11 to 12, they can be upset about it. That is the difference between interference and unreasonable interference. Okay. Two, this is very, very important. Interference with the use and enjoyment of the land. Three, damage. Damage is very essential in nuisance. In other words, nuisance is not actionable per se tort. You have to prove special damages for you to sustain a successful cause of action. This is a very interesting case. Okay. This is also an important proposition on the role of mental element actually. Okay. Mental element in determining whether the existence of liability, then after determining the existence of liability, the determination of the quantum of compensation. The normal rule is for determining the existence of liability, malice is irrelevant. After having determined the existence of liability without taking malice into consideration, for deciding the quantum of compensation, mental element is taken into consideration. This is a case, one person has a resort outside the town. Next to the property, someone was running a fox breeding farm. You know, the foxes were bred for the purpose of bearing what in those days, what is that here? I also wanted to have that with all the wool. What is that? Fur cloth, furring, fur, F-U-R, fur. But the fur has become environmentally unfriendly nowadays. The celebrities shun it. But almost if you see the 1960 Hollywood movie, anyone is of consequence never appears without a fur. And for making this fur, the silver foxes were bred. The defendant requests the plaintiff to change the fox form, okay, to some other place. Plaintiff said, what the hell is my property? I am running a successful business. I'll continue with my business. So what the defendant did is, during the breeding season, the foxes will be very, very sensitive. Knowing this, the defendant fired guns in his own land. That is also not a bad use. If you can run a fox farm in your land, I can run a target practice ground in my land. That's not a big deal. You use your land, I use my land. No bullets reached the plaintiff's land. There was, of course, a lot of noise and vibration. So because of this, what are the direct consequences? 4 consequences were pleaded. This is where the facts are very, very important in law of tort. These 4 facts were pleaded and proved. Number 1, the foxes did not breed. Number 2, even if they bred, they did not conceive. 3, even when they conceived, there were a lot of miscarriages. 4, even when the cubs were born, some of the mothers killed the cubs in rage. So, when there is no breeding and no new foxes being born, you can understand that. Now, we will go back to the slide. These were the damages, that the plaintiff suffered, and naturally he sued. So, in this case, bullets did not go, but sound and vibration went to the neighboring property. And because of something going from your land to that land, be it sound or vibration, the court held that this is a case of nuisance. Okay. And the defendant was allowed to recover good compensation because the plaintiff was also able to prove defendant maliciously wanted to cause damage to compel him to shift to the some other place. So therefore, this is what it is. This is a very important case in private nuisance. Now, I do not see malicious prosecution as part of the syllabi. So therefore, I skip some of this actually. Okay. I think I skipped this. Now, let us come to negligence. This negligence, I will try and discuss along with the Motor Vehicles Act. We may not have a special lecture on Motor Vehicles Act. As I am going to cover negligence to the extent possible, I will also discuss cases relating to Motor Vehicles Act, and hopefully there may be 1 or 2 questions from it actually, because insurance is a big business actually. Okay, even in stock market, some of the top picks today are insurance stocks actually. So it's all right. We will go back to negligence and then come to Motor Vehicles Act. For negligence to be established, the plaintiff has to prove 3 things. Number 1, the defendant owed a duty of care to the plaintiff. One case we will be discussing in law of contract is Donov versus Stevenson. Okay, that is probably the first of the cases in the consumer liability also. And the duty, if it is under a contract, then tort does not come into a picture. So therefore, negligence is a breach of duty primarily fixed by law. Okay. It's different from contract. It is different from custom. It is that their duties can fall on you by a custom. It may fall on you by a practice. It may fall on you by a usage. It can fall on you due to a quasi-contractual relationship. But when it falls on you because of the operation of law, what is that law? That law can be a statute. That law can be an earlier case. And that law can be a fiduciary obligation independent of a contract. So, please understand the 3 ingredients of law of negligence is, number 1, negligence is breach of duty. fixed by law. And again, negligence is not actionable per se. Plaintiff suffered a damage in consequence of the breach of duty. And the damage should not be broken by the chain of causation or remoteness of damages as we discussed in the last class. Okay. Please remember, when I discuss this case, I will also be discussing a bit of jurisprudence. I always believe that law has to be understood in a multidisciplinary way. But then they have not put that in the syllabi. Fair enough, yeah. Donald versus Stevenson, and I am sure you must have heard this case 100 times in your law school days, right? And it is a 1932 case, and this case is spoken year after year in every law school. Virtually there is no law student who doesn't know the facts of this case. Am I right, actually? Okay. Let's go to the facts of the case. Bottle of ginger beer bought in a dimly lit bar. The ginger beer was opaque. Some of the contents were poured into a tumbler and it was consumed. While the remaining were poured, the decomposed body of a snail fell out of the bottle. What a day it would have been for that outing, actually. That's what you call as a date badly ruined because of the bad food and the terrible ambience that prevailed in the bar. All right. Naturally, many of us will puke, right? She probably didn't stop with that. She also the next day had a serious stomach upset. She sued for damages. Whom did she sue? She sued the manufacturer. In America, this is called as the Great Product Liability Suit. You will have lawyers who will enter into an agreement with you pro bono to begin with, spend further litigation, work on a contingency basis, and make the company bleed through their nose, and pay you good sums after taking good lot of money for themselves, actually. That is what I call as the American enterprise at its best. But in India, we do not allow this, contingency fee agreement. And this issue came in Bhopal tragedy, and we will discuss about it when we are talking about that absolute liability. All right. The first of the defenses of the defendant was, number one, there is no privity of contract between the plaintiff and the manufacturer. They went to a bar. The bar guy bought it from me. If they had a problem, let them give the bar guy and take the money. I am not responsible. Two, I think we will discuss this issue. I discussed it when we talked about the law of contract, and we called it as patent defect and latent defect. And we discussed Grant versus Australian knitting mill case also in the law of contract. Dermatitis because of non-cleaning of the fabric softener. But here they said the ultimate consumer should have inspected the content. Caveat emptor. Buyer beware. Each time you take a bottled stuff, pour it everything in a tumbler, okay, and then consume. So, I'm not responsible. Caveat emptor. Buyer is not beware. What can I do? Then, see, manufacturer does not owe any duty of care to the ultimate consumer. The consumer will have a remedy only against the retailer. These are the defenses taken by the defendant. Rejecting all this contention, Manufacturer owes a duty of care to the ultimate consumer. Avoid acts that are likely to harm their neighbor. This is what is called as neighborhood doctrine. In Donald versus Stevenson is an authority not only for contract but also for mercantile quality. That is a contractual principle. This is the liability towards your neighbor. You should not do things that are likely to harm your neighbor. Who in law is your neighbor? Neighbor has been defined as anyone so closely or directly affected by the act or likely to be affected by the act. In another case, the defendant boarded a train but did not bother to close the door after boarding. The door opened outside. This is what you call as a design fault. Nowadays, all doors open inside the train actually. They don't open outside. The plaintiff, who was a porter standing on the edge of the platform, was hit by the door and injured. It was held the defendant was liable because a person moving a boarding train owed a duty of care to a person standing on the platform. They don't have a contract between themselves, right? Every passenger can say that, look here, railway company must close the door. I cannot close the door. Not at all. You are the last guy getting in. Right? You have to close the door. And you owed a duty. You owed it because somebody may be standing in the platform and that person should not be hit. Negligence. I think we discussed it also earlier. Chandni Chowk, there was a clock tower, 80-year-old. Normal life of such a structure is only 45 years. You remember? We discussed it in statutory authority. Municipal Corporation of Delhi having control of the clock tower failed to do the periodic checkup. The clock owner collapsed, resulted in the death of many persons. It was held that the Delhi Municipal Corporation is bound to compensate them. So this is also an authority to the proposition. There can be, but please remember, establishing a clock tower and maintaining it is not a sovereign function. Please make a distinction between sovereign functions of the state and non-sovereign functions of the state. Maintenance of temples. That's not a sovereign function here. Maintenance of hospital, not a sovereign function. Maintenance of army, navy, air force, police forces, definitely they are a sovereign function. Running a telephone company, BSNL, not a sovereign function, commercial function. So the statutory responsibility, statutory authority defense will be available only for sovereign functions and not for non-sovereign function. And in this connection, I have cited you the case of Kasturilal versus Union of India. Do you know that Kasturilal case? I will talk about it along with this Delhi Chandni Chowk case. There was a theft case. Property was recovered and it was handed over to the court. The court bench clerk swindled the jewellery. So the person who lost the money sued the government of Uttar Pradesh. It's actually a very bad precedent of Supreme Court. In that, the Supreme Court held that running a court is a sovereign function and government of India cannot be held responsible in law of tort, and that does not anymore reflect the true position. Whereas this Delhi Chandni Chowk case, reflects the true provision. All right. Unknown to the boy, the omnibus tried to overtake the tram. On seeing the boy, the driver applied the brake. Not much of a distance. The boy was run over, died in the accident. On the case by legal act, this is what you call, this also becomes a case or a defense, special defense called plaintiff as the wrongdoer. The plaintiff himself does something. The accident occurs because of the negligence of the plaintiff. Because he has died, he cannot maintain a case. But nowadays, under the Motor Vehicles Act, there is something called a third party no fault liability. Because the insurance company pays for it, that is a beneficial legislation. Please remember, medical negligence become a very big topic by itself. In United States, the number of medical malpractice suit had compelled all the lawyers to take a liability indemnity insurance. So if you are a doctor without an insurance, you cannot practice. And if your practice is not good, your insurance premium goes up actually. So therefore, people are wondering now this situation here in India. Now, three fundamental principles. A duty of care in deciding whether to undertake the case or not. I have a heart problem. I go to here, what do you call, general surgeon. Okay. Now, nowadays, you will never find a general surgeon performing a heart operation. The reason is a duty of care in deciding whether to, please remember, this is about a normal situation. We are not talking about a medical emergency, not a time like COVID, not in the war front, not after a riot. We are talking about a clear situation where a patient goes to a hospital, gets himself admitted for time and ever. So when you go to a hospital, now, earlier the general surgeons will do surgery for prostate, tonsils, hernia, appendicitis, removal of corns. You understand there are different type of operations and general surgeons normally do that. Now there is a specialist for every discipline and the first decision of a doctor is that, hey, whether I can treat the case of this kind. That's all. A young mother comes to me with a 3-month-old kid. I'm a general physician. I know the kind of problems that are in the market, be it a flu, or a cold, or a pox, or a stomach upset, or a fever. I know what's happening. So I can do that. Second, duty of care in deciding what treatment to give and a duty of care in administration of that treatment. For example, a cancer case come to me, blood cancer. I don't have to subject the patient to radiation. It is enough I give only chemotherapy. But I subject them to radiation and chemotherapy. That may not be the best one. Okay. Somebody will have a, what do you call, throat cancer as well as blood cancer. Then there can be a radiation for the throat cancer and chemotherapy for the other cancer. A duty of care in deciding what treatment to give. For example, many lawyers look at surgery as a solution. And please remember, this is very important. Nowadays they are saying, in many hospitals, there is an alarming increase in the number of cesarean deliveries. About 25 years ago, if there were 100 childbirths, maybe around 10 were cesarean deliveries. Nowadays, parents want their kid to be born on a particular day, right? So they get themselves admitted in a hospital. There is not even a labor, but then the delivery is covered by an insurance. If you are working with Infosys, the company pays. So they go to a doctor and say, let's have a cesarean done. Actually, this is a problem. What treatment to give? Okay, whether you should allow the woman to have a natural delivery or deliver the kid by cesarean. This is a professional decision. Duty of care in administration of that treatment. Actually, I used to tell, I have seen cases where the doctor is good, support paramedical staff like nurse, and the surgery is successful, but unfortunately there is an infection after surgery. The doctor is not responsible, but doctor and the hospital become vicariously responsible because there has been a negligence in the administration of a treatment. This is the next one. This is actually a Supreme Court decided case, 1956 Supreme Court. A motorist met with an accident, admitted to an emergency ward. Senior specialist was not available. He was repeatedly called to attend the patient. The doctor was busy attending to his private patients, could not come to the hospital. Though the contract of employment obliged him to be present in the hospital, the patient died and the doctor was held responsible. He was not there when the patient arrived for treatment, though the law obliged him to be there. In another case, this happened here. The hospital paid something like 5 lakhs and the upkeep of the child till the child achieved 21 years age. Somebody with 7 children go for sterilization, and if the doctor doesn't make sure of it doubly, I think he deserves to pay the compensation actually. All right. Now the important thing is res ipsa loquitur. It only means the thing speaks for itself. Res ipsa loquitur. What happens is, for example, I'll give you an illustration. I have a house. I live in the 2nd floor. You walk on the road, something falls on your garbage, falls on your head. You don't know. You definitely know it fell from the 2nd floor. But you don't know what happened in the 2nd floor so that a bag of garbage can fall in your head. Right? Probably the husband aimed the wife and the wife moved and through the window it fell. They didn't do that intentionally to dump it on you. In other words, circumstances that caused the accident would totally be within the control of the defendant. I don't know what happened here. All I know is that I suffered some injury. And it would be impossible for the plaintiff to prove how the defendant was negligent. How exactly the damn thing fell on my head, I'll not be able to do. So for example, if I fall, this is the illustration, I did that. In such a case, the law will pursue negligence on the defendant. And that is why I said it is a matter for evidence. It is more a principle of evidence than a law of torts. Similarly, the bus is on the highway, brakes fail, causes an accident. In this case again, res ipsa loquitur. If you have maintained your automobile properly, how can the brakes fail here? You must give your vehicle for periodic services. But such a presumption will not be available when there are two options possible. Okay. The plaintiff approached the gynecologist for assisted conception. The doctor advised the removal of possible obstruction in the tube. Various cysts are there, and the cysts will prevent the fertilization. And the doctor carried out a simple procedure of blowing air through the vagina under controlled pressure. Not a bad decision. But subsequently, some infection had occurred. Because of this, the plaintiff's uterus had to be removed. This is a terrible thing. The cause of infection is not known. There is no evidence to suggest that there was no negligence on the part of the doctor to decide to use high-pressured air through vagina for the purpose of removal of obstruction. That's not a bad decision. But therefore, the inference of the negligence of the doctor could not be drawn. But you can draw the inference of negligence in post-operative care. The post-operative care is not in the hospital, and in all these are all procedures, right? So the person goes back home. So unfortunately, this lady could not recover much of compensation. Now, this is a very important defense. Contributory negligence, we talked about general defenses. This time we are talking about specific defenses that are available against specific tort. This contributory negligence is a specific defense available only to causes of action based on negligence. Okay. Let us take a case. It happened here. These cases are all British cases. Some person went to a toilet. The toilet, the doors got jammed. So what he should have done is, he should have waited for people, shouted. His shout will attract the attention of the people nearby. Call somebody from the estate department or maintenance department who will probably remove the jamming of the door and facilitate the escape of the person who got jammed in the toilet. Now, the plaintiff was unable to. What this guy did is, he thought, hey, I'm a physically fit guy. The toilet wall is just about 5 feet. I'm 6 feet. There is a pipe at 1.5 feet. So I'll keep my 1 feet over the pipe, next feet over the wall, and jump out of the wall. Actually, that is what you call, he did that and broke his leg. So why did the accident take place? Number one, the accident took place because the property owner has not maintained the toilet doors in a good condition. All right. But why did the injury occur? The injury occurred because the plaintiff made the wrong decision of having to scale down the toilet wall, which he should not have done. He should have waited for help. So therefore, it is a case of a contributory negligence. The first of the case. This case, Davis versus Mann. Very famous case. Plaintiff had fettered the front legs of the donkey and had left it in a narrow road. You know it is normally done if you had seen donkeys around. Because if you don't fetter it, it goes about 5 or 6 kilometers during night. And thereafter, it will be very difficult for you to take it, retrieve it. So the plaintiff, the defendant, okay, the plaintiff had tied the front legs of his donkey, left it on a narrow road. The defendant was driving his wagon too fast and negligently, ran over the donkey, killed it. In spite of his own negligence, the plaintiff was allowed to recover compensation as the defendant had the last opportunity. The law between 1882 to 1926, okay, was that in case of negligence, the person who had the last opportunity to stop the accident will be held responsible. No matter the defendant himself is responsible for having caused the accident. In other words, contributory negligence is not a defense when the plaintiff is able to prove that he didn't have the last opportunity to stop the accident. Apportionment of damages. As per this method, first method will be computed as if there had been no contributory negligence on the part. First decide type of injury, hospitalization, days, money spent on treatment, nature of disability, temporary disability, permanent disability, time taken for reparation, compensation for pain and suffering. These are the various heads for assessment of damages in MACT. So what you do is, first assess the compensation as if the plaintiff is not at fault. Okay? Then you come to a conclusion, or then you consider the evidence and find out, let us, the defendant is able to prove, look, the plaintiff is also guilty. So you find out what is the contribution of plaintiff to the accident. No lost opportunity rule. Plaintiff is responsible 20%. Plaintiff is responsible 30%. If the compensation payable is 100, deduce this 30% and give him 70. This is called as apportionment of damages, and this is made in Britain as per a change in the legislation. You know, Law Reforms Act 1955. Okay, 1955 or 25, I'm not too sure. All right. Depending on the quantum of the plaintiff's negligence to the accident, the compensation will be reduced. In one case, the bus was crowded. Driver and conductor allowed the passengers to travel on the rooftop. When the driver attempted to overtake a cart, one of the passengers got knocked down by a hanging tree branch. The passenger fell down and died. It was held that the passenger was equally negligent and the quantum of compensation was reduced by 50%. Arey, you cannot get onto the bus rooftop, you know. In Karnataka and North India, I think it's a very regular sight actually, right? They shouldn't be, but many of them sit there, they don't even buy a ticket, pay half the money to the conductor, right? So the court said that 50%, you know, because it's an offense. A driver or conductor cannot permit it, but they do. This is India. Okay. Now we come to a very important change of direction in law. I told you when we were talking about the basis of liability under law of tort. In international law, I said basis of liability, basis of obligation under international law is consent. The basis of liability under law of tort is fault. Fault is the basis of liability. If you are not at fault, you don't have to pay. If you are at fault, you better pay. But this is a case of a departure from, I am sure that all of you know this case, Ryland versus Fletcher, construction of a water reservoir that was constructed by independent contractors. The independent contractors were engineers. They had the skill and they were competent people to make that kind of a decision. And while digging, they found old dispersed shafts under the reservoir. If they have seen this in the normal course, they should observe it, seal it, and make sure that when, you know, hundreds of cubic meters of water is stored, the floor of the reservoir will come under immense pressure and it is their responsibility to seal it. When the reservoir was filled with water, due to high pressure, water burst through the shafts and flooded the plaintiff's coal mine. The defendant did not know of the shaft, and hence they were not negligent. They did not even know. I mean, even though the defendant had not been negligent, they were responsible. So what did the court say? Very, very important ruling. It remained the ruling almost for 100 years. And it had its own defenses. Violent versus Fletcher, strict liability defenses are special. Okay, they are specific defenses. Now from strict liability, we are getting into absolute liability. Okay. And there will definitely be questions on that, because there is also an environmental aspect to the concept of absolute liability. All right. Let us break the judgment. Justice Blackburn. Okay, I remember the name. Okay, even though I have not put it there. When a person for his own purposes brings on to something to his land, something which was not there. So, the first criteria is non-natural use of the land. Okay, something was not there in my land. I am getting that into my land and keeping it. 2. I collected. And if the collected material escapes, and if any person suffers any damage, the person who collected the material, allowed it to escape, will be strictly responsible to the damage. This is what is called as strict liability. Bringing on to something to the land which was not there, collecting it and keeping it is the second criteria. 3, allowing it to escape. 4, the escape has resulted damage. Now, the next case is, this is the law for about 120 years. As M.C. Mehta, you must know actually, is the father of environmental law in India. Okay, you heard a lot about him in the last 20, 30 years. Suddenly you don't hear much about him. Okay, don't know what's the sin, but he doesn't do any cases other than environment. Okay. Supreme Court was dealing with the case. It's actually a very bad precedent here. As a lawyer, as a person, following jurisprudence, I was not very happy with the case. And whenever I say it, I become some kind of an anti-national. You know why? I'll come to the undercurrents of this case later, because I had to discuss with a lot of people. Supreme Court was dealing with the leakage of gas from the factory of DCM, Delhi Cloth Mill. Okay. In this case, the Supreme Court held that when an enterprise is engaged in an hazardous, inherently dangerous activity, very, very simple here, even according to a Stockholm Declaration and a lot of things. Hey, are you doing industrial activity? Yes. Does your industrial activity involve storage of dangerous chemicals? Yes. If they are hazardous to people, if it escapes, yes. Then, if anyone suffers any harm in pursuant of an accident in the operation of such an activity, the enterprise carrying out the liability will be absolutely liable. You know what is the difference between strict liability and the absolute liability?
Difference.
The real difference is, in case of strict liability, the general defenses are all available to have act of the God, act of the third party, plaintiff as the wrongdoer, inevitable accident, voluntary non-fit injuria, novus actus interveniences. That is what is act of the third party. Now, by one stroke of pen, the Supreme Court said that there will be no defense for you here. People die, bloody well pay. That's all about it. That is what is called as absolute liability. Now,
does that mean there's no audio?
All right. Now, please remember, I'll talk to you the reasons for judgment and why I believe that it is not a good judgment. But nobody, but it has become a very, it is now the law. The absolute liability is the law. Actually, Justice Bhagavati has put it. The enterprise carrying out such dangerous activity for private profit. Hey, you are doing a dangerous activity. You are making a profit. When somebody is going to suffer in pursuant of your profit-making exercise, you have a social obligation to pay here. And what you should do is, you should absorb such loss as an item of your overhead. What do? You take a very good insurance policy, right? The insurance policy, all factories have a policy, pay additional premium, increase the cover. It is for you to make a decision. Two, the enterprise alone has the resources and the knowledge to discover this danger. Who has heard of methyl isocyanate before Bhopal tragedy here? Nobody knows. Nobody. They know that it is a pesticide factory. Pesticide factory means they will be using poisonous material, but they know they are using poisonous material, but they don't know that this must be the poison. 2,000 people, 5,000 people killing overnight. Now, very recently, I think it happened in Vijayawada, right? Vijayawada or Visakhapatnam? Samsung. Visakhapatnam. All right. Enterprise alone has the resources and knowledge to discover the danger and protect the parties against such hazardous material. Now, why we say that absolute liability is a bad law? Actually, in the Delhi cloth mill case, the Supreme Court had to decide one main issue, namely, a publicly listed factory is a state within the meaning of Article 30 of the Constitution. If it is a state, a writ would lie. If it is not a state, a writ would not lie. At that point of time, DCM was a privately owned listed company. So the issue at consideration is whether DCM is a state within the meaning of Article 13 of the Constitution. The Supreme Court did not consider that issue at all. It went on to propose this new absolute liability doctrine. The reason was the Bhopal tragedy had taken place. Union Carbide, if they had to be proceeded under the law of tort, for which the lot of litigation and things like that, if Union Carbide had to do that, well, it would have availed many of the defenses, right? They have exercised due care and diligence, and the act is due to third party, namely the electricity board did not give them the power. The power was not there, and because the power was not there, the air conditioners could not work. The air conditioners did not work. There was a heat, and that resulted a chain reaction. All these things. So, Madhya Pradesh Electricity Corporation's liability will also come into picture. So, the Supreme Court wanted to avoid all these things, and that is why they came out with this liability. Right. The only portion that we need to cover in law of tort today is defamation. Actually, I want you to understand, when I say defamation, there are 2 or 3 types of defamation. Anyone in the group? How many different defamations are there? You know libel, you know slander, Is it all? Is there a third one? Any law student will say libel and slander. What is libel? What is libel?
A written defamation, sir. Yeah.
Defamation in a permanent form is libel. Okay. Defamation in a temporary form is a slander. The difference between libel and slander is libel is actionable per se. Slander is you have to prove damage. Okay. This is the distinction between libel and slander. Innuendo is neither libel nor slander. Most of the parodies, they don't accuse that fellow directly. They accuse you indirectly. But they give sufficient indication as to who is that fellow is. I may not say the name, I may not say the town, but I throw a lot of information that will enable an ordinary person to come to a conclusion as to who is that person. So in other words, innuendo is what do you call as a third type of defamation. Okay. Now, a lot of cases here. But I want you to appreciate that under law of crime, both libel and slander are punishable. But in the law of tort, libel is a permanent form and slander is a temporary form and innuendo is an indirect defamation. The indirect defamation may not be punishable under the Indian Penal Code. Okay. Now, there are important defenses, okay, to the defamation. The first defense is justification by truth. Most important cases, US cases, New York versus Sullivan versus New York Times. That is the most important case. In India, Indian Express Newspapers Limited and Times of India, they have had many defamation cases. So, many of these defamation cases are not really prosecuted to the end because Indian courts are not very liberal in granting compensation for defamation. I think I was mentioning you about a defamation case I did. I was able to prove defamation. I was able to prove that fellow was false. Okay. He availed justification by defense. Justification of truth as a defense. He was not able to prove it. Defamation is proved. And the court granted something like 10,000 rupees as a compensation in a matter where, the client spent about 50,000 rupees. So the defamation in India is not really a very satisfactory remedy. Whereas if you look at the Sullivan case, in America and Europe, defamation is really feared, actually. You understand? People like Musk, Elon Musk, he is facing a defamation case in London. And you know what he said? How many of you know that Thailand cave tragedy? How many of you know it? Do you know? There was a football team. It is called Wild Boar. As part of the coaching training, the coach had taken, anybody know this Elon Musk case? The biggest worry today is a defamation case he is facing in London. In that, when he took the kids for an excursion into the cave, there was a flood. Because of the flood, these kids were stranded 3 to 4 kilometers inside the cave. The area through which the kids had to come back was full of water. So, underwater diving rescue operations were undertaken. And that was done by Australian doctors and divers who have been regularly diving there. Now, Musk was into robotics. So he came up with an underwater robotic diving device which he said will retrieve the people from the danger. The rescue team was actually volunteers, doctors, did not agree. And they said, this is thoroughly useless. And this guy is looking for some kind of a cheap publicity out of it. We are not going to use it. And you know what he said? Musk. He accused the doctor to be a pedophile. That's got nothing to do. But the doctor proved at the end of it that he was able to rescue it. He was not actually a pedo. Okay? So he has filed the biggest case in London for defamation, and Musk's biggest worry is he has already offered millions of dollars in settlement. Okay? Huh? And the doctor is still going full hog. All right. Now here, what are the defenses? I was talking to you from New York versus Sullivan Times, Sullivan versus New York Times actually. What they do in this case is, they make a distinction between public person and a private individual. If you are a public person, you don't have a right to privacy. If you are a private person, you have a right to privacy. Okay? So if there is going to be a defamation of a public individual, the damages will be less. If it is going to be the defamation of a public personality in his private capacity, the damages will be moderate. If you are talking about a strictly private person and about strictly private affairs, the damages can be high. This is what is the New York versus Sullivan, New York Times versus Sullivan. Now, when you are talking about justification by truth, what they say is, I may not know the truth all the time. So long as I exercised due care and diligence. I exercised due care and diligence for finding the news. Many times the person concerned will not cooperate. Then two, that was not done with reckless disregard to its falsity or truth. You don't do that, then you are responsible. Otherwise, you are not responsible. Right. Third, what are the defense? Absolute privilege. Absolute privilege is available to parliament, state assemblies, legislatives, and a lot of people. Then qualified privilege. Lawyers, doctors, teachers, all these people have a qualified privilege. Absolute privilege is given by the Constitution or statute. Qualified privilege is given by the operation of circumstances. A lawyer need not be compelled to disclose things actually. He has an obligation to disclose that. I have a duty to assist the investigation. In such situations, I can even talk about defamatory matters actually. I think we have finished the law of tort, but only thing that I will do more is Motor Vehicles Act 1988. Okay. I don't really expect a question. All right. But you must know about three things. No fault liability. It is there in the syllabi. Irrespective of who is responsible for the accident, in case of death, the insurance company will have to pay the victim 100,000 rupees. In case of absolute disability, 75,000 rupees, 50,000 rupees. Okay. This is irrespective of whether the bus or the car is at fault. The reason is a beneficial legislation, and that's it, insurance company make money, but if you given a choice to Indian insurance companies whether they would like to exit the insurance business, they'll very gladly do that actually. But the law company, they don't make money in this. They make money in health insurance. They make money in other types of insurance, burglary insurance, fire insurance. Then they do a lot of what you call hedging transaction, foreign exchange insurance, export credit guarantee, lots of insurances are there. They make money there. But none of the insurance companies in India are making money from motor accident insurance because the amount that they get as premium is lower than the money they end up paying to the automobile owners. Even the parts, they are entitled to reimbursement. If I have a bumper to bumper insurance, that's what you are talking about. The accident occurs, you have to pay. That's all about it actually. And whenever there is a great calamity, natural disaster and all that, the insurance companies end up paying a lot of money. I think I am finishing my class.